Our resident lawyer, Despina Priala of boutique law firm Priala Legal in Runaway Bay, is with us every Thursday to offer her legal expertise by providing some general advice on the latest hot topics, of course having experience spanning more than 25 years in the area of property and commercial law. And she joins us now. Good morning, Despina.
Good morning, Brooke. Good morning, Steve.
Morning.
We have a hot topic this morning. We're talking contracts.
We are. So obviously this is right up my alley, and I do contracts all the time, specifically for property. And I thought we'd talk about where contracts go wrong, because contracts can go very wrong and a lot of people don't really understand it. And I guess if I can start by saying it's almost a bit of a stigma, I think, out there in society, where people think that when they buy and sell property, that it's a very simple, easy process. It should be by rights, but it's actually not. It couldn't be further from that. It's quite a complicated process, and we don't overcomplicate it. But what happens is that the process can become complicated, where consumers are out there wanting to buy and sell property, and they don't get that advice before they actually sign the contract of sale.
Okay,
Yep.
so what main complications are you kind of looking at the moment? What is the top three, would you say?
So, look, there's many examples where contracts can go wrong, but I think the most important thing is that people are out there, on weekends or at night time, and they're talking to agents and they sign the contract without getting that advice. Now, those contracts obviously primarily are prepared by agents, and we as lawyers are trained to look for particular things that are important. And buying and selling property is one of the most important decisions that you make in your life. And moving house is actually one of the, I think, the top three most stressful events that people can go through. So we try to make things as smooth and easy as possible for our clients. And the really the best way to do that is to send us that draft contract before you sign. We know what to look for, and we know the pitfalls, and it really comes down to what you want in your contract. So I had an example recently where I said to a client, he was on the hunt for a property, and I said, look, make sure that when you find the property that you're interested in, you want to put an offer in, give us the contract before you sign it, so we can actually vet it for you and talk to you specifically about what you're looking for, why are you buying it, what we need to cater for in that contract for you, because each contract and each buyer and seller is different, and each person's buying it for a different reason. So he said, yes, yes, yes. So, of course, he did the exact opposite, and I have no idea why. And he signed, and clients do this a lot, unfortunately, and he signed the contract. Now, a week into it, once obviously he signed it, the seller signed it, the parties are bound. So there's no ability to change without going through another process. So he said to me, within a week, look, I want to have it subject to a pest and building report, because it wasn't subject to that at all, which means he wanted to engage a consultant to go through the property and have a good look and give him a building and pest report to see if there's anything wrong, particular things to look out for. And your standard contracts cater for that. So the standard contracts provide the ability for buyers to negotiate. I want it subject to finance. I want it subject to a pest and building report. I want it subject to certain rectification works to be included. I want a swimming pool fence put in by the seller before settlement. A whole range of things can be negotiated. But it's at that pivotal point before you sign the contract that you need to negotiate these things. So I said to him, well, that's going to be difficult because it's not subject to a pest and building report, and therefore I have to ask the seller to agree to that variation. And of course, perhaps you can predict what happened. The seller didn't agree. And then he was left with, oh, well, what do I do now? And I said, well, it's difficult for me to help you in this situation to get what you want, because you've already bound to a contract. The seller says, well, I don't have to agree to a variation. Too bad. You're stuck with it. You buy it as it is, or you don't. And then he even just wanted to come through the property with an inspector just to have a look. And under the contract, you're not allowed to do that unless it's subject to a pest and building report, you see. So buyers don't understand that. And that's why it's very important for buyers to come and talk to us before they sign, because we understand how the contracts work.
See,
And if you don't have...
he signed the contract, and that makes it really difficult for you now.
Yes, that's right. So he missed out on having that subject to a pest and building report, and then he had to decide, well, am I going to go ahead or not? And that's a difficult decision to make, very difficult. So in the end, he decided to go ahead anyway, perhaps with some, risks associated, which really he could have minimised those risks by coming to see us beforehand. It's a very simple thing. Pick up the phone, get the agent to email us the contract, and then we vet it for the client and we talk to the client about that. So it's really important.
Yes, it is important, and it does sound that the pest side of things when buying a home, I could imagine that being obviously fairly important, but there would be other factors, I'm sure, that are far more serious. Can you give any examples of stuff that we should look out for that are on a bigger scale?
A really good example is where you're buying a property that has a tenant in it. Now, obviously, that's got to be disclosed by the agent and it has to be put in the contract. Yes, there's a tenant. But sometimes the parties negotiate that the contract subject to vacant possession. So that means that the seller's got to get rid of the tenant before settlement because perhaps the buyer wants to move in themselves, or maybe they want to have it empty to renovate. Who knows? So if there's a clause in there that says subject to vacant possession, that's all very well and good. But what buyers often don't think about is, well, when I'm due to settle, the state and condition of the property might be pretty woeful. And it actually is quite a bone of contention for a lot of buyers because you can imagine the practical side. The tenant's got to vacate before settlement, so it's got to be empty. And the tenant has their own obligations with the seller under their tenancy agreement, do a bond clean, the usual thing, make sure the carpets are cleaned. That's in pretty much every tenancy agreement. But what if the tenant doesn't do it? And what if the tenant doesn't do it by the time you're due to settle? So then you're left with a property that's, pretty grotty, could be infested with all sorts of things. Carpets are pretty awful. They're stained. And as a buyer, you cannot do anything about that.
And what if someone isn't signed to a lease? So I actually know someone personally who wasn't signed to a lease, and there was a bit of a kerfuffle there because they had to get out within a certain amount of time. Don't quote me, I think it was about 30 days. And there was no lease there, but there was stuff already damaged to the property. So as they were leaving, they were meant to fix all these things for the owner. And it was the kind of this back and forth thing because it was like, who is actually at fault here? Is it the tenant or is it the owner for not placing that lease and having those guidelines set out clearly for them?
It's a really good point. We see this all the time. Now, this is almost not an easy fix. It's an easy fix for me because I know what to put in the contract. But for others who are novices at this, it's not. So what we do is we put conditions in the contract where there is a tenant, where it's subject to vacant possession, where you know that the seller's got to get rid of the tenant. And we put in there a specific clause that we drafted a particular way where it says that, look, there is a tenant, they've got to vacate, it's got to be done by settlement. Otherwise, first of all, the buyer doesn't have to settle. Second, the seller has got to make sure that there is a bond clean, that the property's clean, it's in a tidy state. So all of that wording has got to be actually put in the contract to the point where the buyer doesn't have to settle if it's not done. And we don't see that often in contracts because people don't think about that and they don't get their contracts vetted. And you have the exact problem that you're talking about. Because often when these clauses are drafted by agents about, the seller's got to put a swimming pool fence in, the tenant's got to vacate, it's usually just a one line and it doesn't say what happens if they don't. What are the consequences if it doesn't happen, if it's not done right? What are the buyer's rights? What are the seller's rights? Those are the things that we draft in a contract so it's not left open slather for each party to then interpret as to what they can and cannot do. Buyer comes to me, can I terminate? Can I get my deposit back? Can I get compensation, which is a big one? Well, no, I'm going to have to negotiate that for you now because it wasn't in the contract. So these are the things that we look for from the beginning.
Hot Topics talking about terms and conditions with contracts with Despina Priala from Priala Legal in Runaway Bay. Like to call them 0755 29 1294. In our next segment, council culture. It's another hot topic, but what exactly does it mean? Back with more in a moment.